May I please, your lordship? My lord, I beg to mention item number 19, my lord. Because of some personal difficulty, my lord, I pass over for the day, my
Item number 19.
19.
On the respondent side, one Mr. NH Daskar is also there.
I will inform, my lord.
At the request made by learned counsel, waiting for the applicant. The matter is adjourned for the day. Raised here by the raised matter.
Obligation.
Yes.
May I please, your lordship? I beg to mention for item number 11, lordship. Admission
number?
column.
9.
11, lordship.
11.
The learned counsel for the item number 11 is sick, lordship, due to which he couldn't able to come. That's another point.
On the other side, MSPB Bora was there as a legal aid. You
Lordship.
have not informed him.
No, lordship.
Give information to her also.
I will.
Regarding the adjournment.
I will let him know during the day, lordship, because my senior is sick, lordship.
Who is your senior?
S. Hajarika, lordship.
S. Hajari. You are
P. Lamu, lordship.
MSP Lamu, appearing on behalf of Mr. S. Hazarika and submitted that due to his ill condition, he is unable to appear before. Okay. After she further submitted that she will inform the other side in view of this, the matter is adjourned. You want
Look,
any fixed date here?
Yes, lordship. There is an interim, lordship. Maybe continue till the next day. Can be matter fixed on 16th of July, June.
Even 17th. 16th is there are many matters. 17th. 17th of June. Yes, from 17th of interim was there, na?
Yes, sir.
Interim be continued till later.
Duly blessed.
Lordship, I beg to mention item number 8.
Item number 8.
Yes, Your Lordship. Here, the arguing counsel for respondent number 2 is unavailable today due to some personal difficulty.
What, Mr. Nawaz?
No, Mr. Laskar. Mr. Nawaz, I'm representing Mr. Nawaz for R4.
R4.
Yes.
And Mr. Laskar is for R3.
R3, yes. So he is unavailable today due to some.
But have you informed the petitioner side?
Petitioner side.
You are available.
Yes. For interim order may be continued.
Interim was there?
Yes.
Mr. You are Mr. Majar Bhaiya?
Majar.
Mr. NH. Done his petition. Also heard Mr. A. Mishra appearing on Mr. S. Nawaz, the respondent number 3, submitted that due to personal inconvenience of the counsel for the respondent number 3, Mr. S. T. Laskar, paid for an adjournment, to which Mr. Majar Bhaiya raised no objection. We are adopted. It's the 15th will do, 15th of June. It's on 15th of June, interim be continued.
May I please, your lordship? Lordship, I beg to mention item number 13 and 14. Lordship, conducting counsel is out of station. The matter may be passed over for the day, lordship.
Yes, what is the position of 13 and
We have received the case there, Your Lordship. So we have retained it. If long dead, then we have sent it back.
Lordship, any day on the next week.
Next.
one BA is there, one AB is there.
Yes, Lordship.
So for considering BA, we thought that next week, any date, 5th of June. 5th of June, at a request made by learned counsel for the petitioner appearing on Mr. H. Matters are adjourned. However, it is submitted by Mr. D.P. Goswami that the CD received. Retain the case diary till next date of listing. Listing matter according 5/6. Okay, we're retaining the case diary till 5/6.
Bacho.
Lordship, I beg to mention item number 16.
16.
16, Lordship. In this matter, CD has not been received.
Yes,
We have
got
not
it.
received the case diary, Lordship.
We are on interim.
CD not received, issue reminder. Yes, Samir, when it can
19-6.
list on 19/6, interim be continued till next.
Same player for item number 17, Your Lordship.
17 also, same order. In 17, we have
17
received,
also not case diary received.
not received. Same purpose,
19
same order.
Interim is also there.
Yes, in 19/6, both. will mention.
19-6.
Okay,
Another
connect,
date,
not a connected matters, huh?
not connected. Lordship. Can it be 20th or 21st?
20.
Yes.
Lord,
9 for item number 17.
20 is holiday,
Okay.
22nd.
In 17, you are saying,
Yes, sir.
or 17. In that case, we have 22nd of July.
Lordship.
Obliged, Lordship. Lordship, bail application.
Yes.
It's FIR is under 103, Your Lordship. Allegations that while the victim was in her matrimonial home, she was given poison and ultimately she died. Lordship will
Case
probably
diary?
require
Every-
case diary.
How many days in custody?
35 days in custody already.
It is from Tezpur, I think.
Yes, we test for 35 days, 17th of June. Lordship.
Lordship, both members are senior citizens. I will like case diary may be called, but shorter date may be fixed. 8th or 9th of June, Your Lordship.
9th of June.
Obliged, Lordship.
CD withdrawal for 9th of June.
Well, the allegation is that, my lord, I established physical relationship with the informant's daughter, who is a medically challenged lady, 27 years old. And thereby, my lord, she has been, my lord, impregnated by 7 months. When she was 7 months pregnant, the informant came to know. So thereby lodged an FIR. The police collected the sample of DNA from the child born out of, my lord, from the lady. Now, my lord, the anticipated bail I am seeking, just I want to, my lord, provide the DNA sample of mine, my lord, to prove the fact that, my lord, I am not involved in this offense, my lord, alleged offense.
No, DNA sample is already been collected or not yet?
Collected from the, my lord,
Child.
child, my lord. Now, I also want to provide, because, my lord, this is an allegation. In fact, I used to provide all the care to the, my lord, mentally challenged lady. I used to have the informants, my lord. Somehow, my lord, I don't know out of what intention the FIR has been lodged. So I want to visit the police station. I want to cooperate. Once my DNA sample is collected, my lord, everything will be crystal clear. Unless and until my DNA sample is, my lord, collected and provided, so nothing will come out. I am on a run, my lord. The police is behind me for this allegation. Just a protection may be given. I may be allowed to visit the police station so that my sample may be collected. I will cooperate with the investigation.
But we have to go to the victim statement is required in this case. So,
Yeah, obviously, it's a kid.
yes.
But she's a mentally retarded or physically retarded?
Well, mentally
She's
challenged, well,
mentally
mentally challenged. While she was being examined in the mental hospital Tezpur, the doctor came to know that, my lord, she is 7 months pregnant. It is also, my lord, not because the informants reside with her, my lord. He has to know what was going on with the, my lord, daughter. 7 months pregnant, he was not aware, my lord. Something, my lord, fishy, my lord.
So, this I pray for case diary only, Lordship.
Case that in the meantime, my lord, I may be protected. I want to visit. Unless and until I appear before the police station, my lord, the truth will not come out. And if my DNA sample matches with the, my lord, DNA of the child, my lord, definitely then I am involved. Everything will be crystal clear once I appear. My DNA is collected. So it will, my lord, expedite the investigation. Just for that, my lord.
Whether DNA sample is taken or not from the child, Lordship, it will reflect on the case diary only.
No, it is taken, my lord. In various orders, my lord, it passed, my lord. It is taken. Because I applied before the learned session judge, my lord. The bail was rejected. Here the observation was made, though I have not annexed that order. Eh,
Please go Sami.
Only case day only, after that, after closing the case diary, even nothing is found with against petitioner, then.
Yes, case diary is necessary. I am not denying the fact. Case diary is necessary. In the meantime, I'll be allowed to appear before the learned, before the IO, but it will expedite the investigation rather. In the meantime, case diary will be called for, and if I am involved, your lordship will decide. And if my DNA sample matches with the child, definitely, my lord, I am involved. It will rather expedite the investigation. My lord. For the purpose of expedition of the investigation, I am just praying.
Parties as specifically done after the petition, also parties with the people done additional application section Swenson submitted by Mr. Respect that there is an allegation of rape against the present petitioner with a mentally challenged girl of maybe 7 years, and it is also alleged that she got impregnated by him. As per his instructions and from the office of the vital court bill, it has come to the knowledge of this petitioner that the the child born from the victim, and no, the DNA sample has already been obtained from the child born from the victim and for analysis. But the truth will only come in that aspect if the DNA sample of the present petitioner is also collected correct. The petitioner is ready to give his DNA sample for analysis, and however some protection is to him so that he can appear before the IO and can cooperate in the investigation, and this may also expedite the investigation of the prejudice. Next, Mr. Kusami learned additional raised objection and submitted that at present there is no evidence as to whether any DNA sample has been collected from the child of the born from the victim, and in the same time, it is an allegation of rape against a mentally challenged woman, and hence he insisted on against it, considering the entire facts and circumstances of this case, and also finding it necessary for examination of not analysis of the DNA sample of the petition. This court is of opinion that an interim protection may be provided to the petitioner so that he can appear, can provide his sample, and also cooperate in the investigation of this case. Last a copy of order may be supported with the notice to be issued to the investigating officer for to make this because he submitted only on that regard that he is interested to give his sample,
Yes.
DNA sample. So the order of this court should accompany along with the notice. Take a certified copy of this order. Not certified, you not need certified. Copy of the order should be accompanied with notice. That will be the order. When
Much
it will
obliged.
be listed.
22nd.
Much obliged.
Maybe listen, Lordship. Lordship, anticipated bail, Lordship. The petitioner is serving as postman, Lordship, in Bongaigaon, Golpara Division, Lordship. Now, Lordship, the petitioner, Lordship, kindly, Lordship, at para 6, Lordship, that on 15/5/2026, Lordship, at about 1:19 p.m. on Mr. Deepak Sarkar, in search of New Bongaigaon Police Patrol Post, called the petitioner, Lordship, and said that there is a pending case against the petitioner, Lordship. Now, Lordship, actually matter related to Lordship, the brother-in-law of the petitioner, Lordship, on Mohibul Islam, got married with on Rustana Begum, Lordship. That in the last week of April 2026, Lordship, Rustana Begum left her matrimonial home, Lordship, and thereafter to amicably settle the matter, Lordship, on village meeting was done, Lordship. There the petitioner was present, Lordship. Now, Lordship, after calling, the petitioner has visited the PI court, Lordship. There is no such record against the petitioner, whether any case has been registered or not.
The report may be called for.
Lordship, Lordship, why it is very much essential to protect me, Lordship. I'm praying for protect me, Lordship. Police is calling repeatedly, Lordship, to appear before the police station, Lordship. Lordship, I'm serving a postman, having reputation in the society, Lordship. I'm ready to cooperate, Lordship. Kindly protect me till then, Lordship. Record may be called for whether any case has been registered or not, Lordship.
Mr. K. Also. Mr. D.P. Goswami.
From Bongaigaon, yes.
Every year. It's an and section 482. Yeah, this is for the state, but it's submitted that the police is searching for the present petitioner, and in that paper, the police officer from Bongaigaon, New Bongaigaon PP, police headquarters, New Bongaigaon PP has also called this present petitioner for the asking him to appear before the police station. And then he has come to know that there is no case against the present petitioner at present. However, it is a fact that the wife of his sister-in-law, Rustana Begum, who left her matrimonial house, and in that context, one village meeting was held wherein the present petitioner was also present. However, first, the petitioner is ready to cooperate with the case if any case is registered against him, and if he is provided with some information. Next. Mr. Kusami Dilane, additional PP, submitted that a report may be called from New Bongaigaon police station as to whether any case has been registered. Next, considering this submission made by that, say the police report be called for from New Bongaigaon police station as to whether any case has been registered against the present petitioner. Until the receipt of the report, police from New Bongaigaon police station is hereby not to take any prosecution. Is the matter, I guess, brought forward when
22nd or
22nd, so long. It's a report only.
not even 19 Lordship.
1906.
Protection has given Lordship.
Deeply obliged, Lordship.
Lordship, the FIR at page number 1313, my lord. 13 is the FIR. The event would be, my lord, page Roman 2, my lord. With reference to
Roman 2.
Roman 2, my
lord.
With reference to caption above, please take note that AGBP Lalabajar branch had financed a vehicle with so. It's a details of the vehicle, and accordingly entered into an agreement with bank on 23rd October 2024 to pay the loan in 84 EMI, each commencing from the next month of disbursement. Further, vehicle shall remain hypothecated to the bank until complete liquidation of the loan. The vehicle was registered with TPO Kampu on 29th October 2024, bearing register number 12. However, during our periodic inspection, it is observed that owner name has been changed to Pinky Das, and financier bank has also been changed to HDFC Bank, which is a matter of great concern as borrower has neither liquidated the loan nor obtain NOC from the bank. Now, my lord, in this case, lordship, the petitioner purchased the vehicle, my lord, on loan, my lord, and initial 8 installment he could deposit, my lord. Subsequently, because of extreme financial hardship, my lord, he given physical possession to one Abdul Qasim, my lord, with certain condition that, my lord, Abdul Qasim will continue to pay the entire EMI, my lord, and thereafter, my lord, all the petitioner would do all the need for change of the ownership of the vehicle by providing document. Now, what happened, my lord, during that period, my lord, petitioner was not aware about this fact, my lord. During routine checkup, when these things happened and legal notice was sent to the petitioner, my then on inquiry, he tried to contact that Abdul Qasim. He did not turn up. And then he searched M-Parivahan apps, my lord. He found that the vehicle has been changed, my lord. Now, my lord, name was transferred to someone Pinky Das, my lord. In this case, in such cases, my lord, to transfer ownership, my lord, NOC from the finance provider, that is the bank, is required, my lord. Now, my lord, petitioner is not in any way involved in this.
He purchased the vehicle
My
initially.
lord, my lord. Now, my lord, thereafter, because of this, he filed a title suit against the Abdul Qasim and other person, but against bank, my lord, because NOC was provided by the bank, my lord, to the TTO, my lord. And that title suit
No,
is
but
pending.
here it is seen that NOC was not, they were not taken any NOC from the bank.
No, this is their allegation, my lord. Now,
Their allegation.
my lord,
Then where from you are saying that there was an NOC?
NOC, I am not saying NOC, the petitioner has not submitted any NOC on behalf of the bank, my lord, because, my lord, until and unless the entire loan amount is liquidated, my lord, bank will never.
No, that's what the bank is saying.
Now,
Then?
my lord, in between that, my lord, though it is not permissible because of financial hardship, physical possession was given to one Abdul Qasim, my lord, and
But name has been changed now.
a name has been changed, my lord. In between that, my lord, it was changed. Finance name, bank also, finance provider also changed, my lord. Now, my lord,
That is the allegation against you.
my lord.
Then?
And for that, my lord, even
You are saying yes, right. You cannot, without the NOC, you cannot change.
my lord,
But this is the case of the petition, I mean, informant only.
my lord.
That you have changed everything.
No,
Name of the owner is changed. They were without any
well,
NOC.
for
The
that
bank
purpose, even I
financial
have
is
filed a
changed.
title suit before the landed.
No, you may file a title suit.
Title suit,
The
well,
allegation
that is pending.
clear against you.
That is pending before the trial court also, my lord.
No, whatever. But the question is that what trial suit?
Title
else?
suit, I have annexed, my lord, page.
No, what do you what is your relief praying for?
Relief paid, my lord, page 21, my lord.
I'm saying filing a title suit is not sufficient. Yes, what is? Mandatory
For
ending
declaration, have
prohibiting.
no right title.
You have transferred the matter now. Whom you are saying not prohibiting?
He purchased the vehicle. He is the owner of the vehicle without in the higher
Who is
person.
Abdul Qasim?
Abdul Qasim, my lord, in between that, the petitioner, my lord, herein, my lord, because of his extreme hardship, my lord, he has given the vehicle to Abdul Qasim.
So was there any agreement?
My lord, in such my agreement, there is.
What? Yeah, how we can you have
Or-
no
oral-
authority
oral-
to
on
file
the-
a title suit against one said Abdul Qasim.
On the basis of oral agreement, my lord, he obtained a 3,50,000.
Now at this stage you don't have any locus standi even to file a title suit against this
No, my lord,
I mean one Abdul Qasim. He is not involved.
No, my lord, already, my lord, that title suit is pending, my lord. Defendant appeared, they are filed their, my lord,
Obviously they will appear
written statement.
because you
My lord,
cannot file any case.
my
So,
lord,
not
when
a
my
case
bail,
of- Now see, we give the liberty of appearing in anticipatory bail because if there is an agreement, simple violation of some terms of agreement or there is
My-
some agreement, in that case, it can be. But here in this case is a cheating directly. Name of the petition is ownership is also changed. The bank financial institution is also changed. How?
my lord,
It
DTO,
says you only.
now, my lord, when it was submitted for the district transport officer, my lord. My lord, NOC petitioner cannot provide the NOC, my lord. It is the bank, my lord.
That's what the bank is submitting. Without NOC, you have transferred.
How can you transfer?
Obviously,
My lord,
you cannot file any NOC.
My lord,
But
even,
this is a case of the bank that without any NOC, how can it be transferred?
Lord.
That is a case of the bank itself.
My-
It's not your case. It's
my-
a case of the informant only. Okay, we call for the case diary. CDB call. no protection can be given. Yes, when he is not on interim, right?
76.
76.
Applied.
May I please, Your Lordship? So anticipatory bail application, here the petitioner is a juvenile, Lordship. FIR, Lordship, would find in page number 13. So the allegation here is that 3 minor daughters were kidnapped by 3 youths, Lordship. It is alleged that 3 minor daughters were kidnapped by 3 youths, and this present petitioner, Kalua, alias Abdul Razak Ahmed, assisted him in kidnapping. He provided assistance, Lordship. And subsequently, Lordship, what happened? This present petitioner, who is a juvenile, his e-rickshaw was hired by 1 youth and 3 young girls, Lordship, and requested him to drop them at uh, railway station, Kamakya railway station. Accordingly, he took them to the Kamakya railway station, and in the meantime, they were followed by their respective guardians, and they were caught there. And this present petitioner, he left the e-rickshaw and then fled away, Lordship. 1 boy was arrested, and he was released on bail later on, being the juvenile, and the girls were also recovered instantly, Lordship.
If you are juvenile, so why you are
No,
apprehending?
Lordship, police is looking for me, and my
No,
police
you are
is
looking for it,
threatening,
everything
threatening my mother that they will arrest me and
he
put me
will be
behind the bar.
forwarded as a juvenile only. No issue on that. You will be forwarded as juvenile.
Yes, Lordship.
Why anticipatory?
Lordship, yes, because police is threatening,
That's
and
what I'm
the
saying.
mother is,
Even if he's supposed
mother is,
forwarded, he will be released because if he is a juvenile.
Lordship.
If-
Lordship,
but the allegations
I am ready to
15
appear before the
girls who have been kidnapped.
Lordship.
All are minor girls.
All are
14
minor.
or 14
They were
years.
not kidnapped, Lordship. They went to go for a trip, Lordship,
With
along
whom?
with their friends, Lordship. 1 boy and 3 girls, Lordship. There were no kidnappers, Lordship. And he just dropped them in the Kamakya railway.
The parents were worried.
Parents went there that suspecting that they were kidnapped by the boys, Lordship.
Why such kind of suspicion? 3 girls went for a trip with a boy, no issue.
Yes.
Then
So it is up to the informant, Lordship, why they have suspected that they were kidnapped, Lordship. Subsequently, they all were recovered, Lordship, and they were in the
Okay.
custody of the guardians.
No, I'm saying why you are worried. If you are a juvenile, then okay, you will be forwarded as a juvenile only. No issue on that.
Even though, Lordship, if protection will be given, I will appear before the IO, Lordship.
What will appear? Yeah. Yes.
Oh, protection cannot be granted by protection or like, because he's also only a juvenile now again. 15 years.
16 years.
16 years old.
In that
Open-
context, have you furnished anything?
Yes, Lordship, I have
Certificate of the
birth certificate as well as the school admission.
His father name is?
Father name is Rocky Bull Ali. Page number 16, Lordship, birth certificate, and school admission in page number 18, Lordship. Is in studying in class 9, Lordship.
being a juvenile, he cannot write out authorize edicts also.
Actually, Lordship, it was not in his name, Lordship. It was in his brother's name, and in absence of his brother, he drove it. And subsequently, the EXO was it was seized, and custody was given to the brother also, Lordship.
If you go to the allegations are serious. 3 minor girls were kidnapped as per the allegations.
But steady may be called for. In the meantime, Lordship, I may be protected. Right. Okay.
From you're saying they all recovered or rescued?
They were recovered. At the time of filing, although they have written that their whereabouts are not known, but they were recovered.
Before us, though, there is nothing.
That's it.
In regards to their recovery,
No.
because
So we do not
allegation
have
is
any
very serious
support of
because
that.
in before
So
us there is
city
no
may be called for lordship.
the city be called for because before us there is nothing, in fact.
There is nothing lordship.
Because till that the descriptions of those kidnapped girls were there.
There, yes.
But regarding recovery or their recording of statement is not there.
Lordship,
Is there any
subsequently they
information
might
from-
have been done lordship, but it is not in our record lordship.
Pardon?
Perhaps subsequently their statements have been recorded lordship.
So you could have
But,
obtained the certificate copy, in fact.
So, but we do not have lordship
No,
at,
no,
at
no.
present
At
lordship.
present you don't have.
At present.
Could have obtained the certificate copy of
Yes, Lord.
orders.
Yes.
Then only we can come to know that yes, they are already got recovered
Lordship.
on the day itself.
Lordship.
Because Mari Katipelabo Bhabuki said these
Yes.
are also there. So we don't know the whereabouts of the girls also at present. As you have submitted rightly, most probably because there may be recovery. Let us call for a case diary. We'll see.
Lordship.
City be called for video when it can be. He is not on interim, so we 10 or 11.
Deep level.
May I please, your lordship?
Okay, pre-arrest bail application, lordship. Lordship will find the FIR on page 12, lordship.
Short FIR, lordship. May I read the FIR?
I, Sri, complainant's name, so and so, respectfully submit this complaint of zero FIR against the accused Lawrence Weke and so and so. Point one, that I have rented out my vehicle to the accused under a valid sub-rent agreement bearing certificate number so and so, which was signed before the notary Gauhati, Kamrup, Assam. As per the terms of the agreement, the accused had agreed to pay me a monthly of amount of rupees 18,20,000. That was part payment of the said liability. Accused issued 2 check on 31/3/26 at Hengrabari, Gauhati, Assam. Check number so and so. However, upon presentation, both the checks were dishonored by the bank due to insufficient funds, thereby clearly indicating fraudulent intention and financial deceit. That despite repeated requests and demand, the accused has failed and neglected to make payment of the agreed amount, thereby causing me severe financial loss. That the accused has accommodated me along with the driver of the hired vehicle in hotel so and so, Nagaon, Assam for 4 days. After 4 days, we were sent to Panifaiti, Narengi, Kamrup, Assam, but while we were leaving the hotel, he was unable to pay the rent to the hotel due to non-payment and act of the accused. My associate Sri, because they Alto Ketan vehicle bearing number so and so was wrongfully seized by certain individual associated with the hotel Nirmala Lodge, Roha, Nagaon, Assam, causing further loss, harassment, and mental agony. That the act of the accused clearly constitute offense punishable under criminal breach of trust, fraud, cheating, along with the other relevant provision of law. Lordship, the sections which are implicated
Now
in this-
against whom the case is filed? Fine.
against Lawrence Weke, the present petition,
the person who took
the vehicle, and subsequently he had made another agreement which I have annexed, Lordship. On from page 19, Lordship. The agreement was made with one Abul Qasim, Lordship. Lordship, actually the contractual work which was supposed to be held, it was for the ring road project which was the construction was going on. For that, the vehicles has been taken, Lordship, but subsequently the tender got cancelled. And even the loss which was faced by Lawrence Weke is similar to the complainant. And complainant has already stated in the FIR that he has that some checks were been issued. Bona fidely, some checks were issued. Now, Lordship, both the parties are similarly affected and they can approach the appropriate civil court, Lordship. And checks are also there, Lordship, and damages caused to the complainant are similar to the accused because the present petitioner also has the same agreement with one Abul Qasim, Lordship. And they can both file, they have civil remedies available. Both NIAC proceeding can also be drawn by the complainant, and in the meantime, the petitioner can also approach the civil court, Lordship, because they have the agreement, Lordship. Civil remedies are available, Lordship. Bail may be granted at this stage. With that.
Yes.
The agreement was made, lordship, payment was not regularly paid to the complainant, lordship. So at this stage, lots of vehicles are there, lordship, and 18,20,000 per month. It's a
Lots
huge
of
amount.
vehicles, mean how many vehicles?
Vehicles are as per the agreement, lordship.
Total numbers of vehicles are, lordship. Vehicles are already with the complainant. We have not obtained any vehicle. They came with the vehicle. They have to went back away with the vehicle. That is there in the FIR.
That will reflect on the case only, but otherwise.
No, if they are the complainant, the vehicles are still with the complainant, then why this case is there?
Complaint was lodged.
Because of
It
the
was on
payment.
rent.
Because of the payment which has not been received by the complainant. The
So
FIR
for
is
some months it was used. Those
no,
were
no.
used.
It was not used, lordship. Lordship will find it in the FIR itself. They came with the vehicle. They stayed in a hotel. They had the driver also. The complainant has the driver and the vehicle. They stayed in the hotel, but subsequently the petitioner did not make the payment because his agreement with the Abul Kasam stand that from his part he did not receive the payment. So they went away with the vehicles. His allegation is not regarding the any keeping of vehicles by the present petitioner, lordship. Vehicles are with the complainant itself. Because drivers are also of the complainant itself, lordship. It is there in the FIR, lordship. The accused, point number 6 on page 12, lordship. The accused has accommodated me along with all the driver of the hire vehicle in Hotel Nirmala Lodge. From there, they have went back, lordship, after the payment was not being made by the petitioner.
An agreement was made on
Agreement was made.
30 March 2026.
Yes.
And the complaint was lodged on 4/5/26.
Part study immediately done is not qualified. So DP to some opinion BP appearing on it's an application on 6 Wednesday. It is submitted by Mr. Mehdi that the petitioner is innocent and committed any such offense as an clear. However, it is the fact that there was an agreement between the informant and the accused petitioner for hiring some vehicle from the informant, and to that effect, an agreement was also executed between them. He further submitted that the petitioner in turn also had an agreement with one publication for a work wherein they were supposed to hire those vehicles, but subsequently did that that work order was cancelled, and the petitioner had to face potential loss similarly with the in a similar way with the complainant. On good faith, he also issued 2 checks to the informant, but those were not related to his financial position. However, the petitioner is ready and willing to extend his cooperation in further investigation of this case if he is provided with some information. He further submitted that considering the nature of allegation brought in the FIR, may be a case of civil in nature, and in the same time, the complainant also has the option to file a case under negotiable instrument. So to submit an insisted all for the case dead and submitted that the agreement was made between the parties, but thereafter the petitioner cheated the informant. Considering this submission by statement made in the file and the other annexures filed along with the petition, this court did opinion that some interim protection may be provided to the present petitioner. Okay, will be some under interim protection.
22nd. We have not up to date case diary was called for, but we have not received the case diary yet. It is TCR received we have, but further for further investigation, I have made a prayer before the learned trial court for further investigation. So that's why CD may be taken back by the IO from the learned trial court. So
CD means case.
case diary.
record.
Case diary. So this case was otherwise charge sheeted. Trial was
Charge
going
sheeted,
on. Subsequently, the informant made a prayer for further investigation before the trial court. That prayer was allowed. So CD was sent back to the IO, my lord. So on the last occasion, your lordship was pleased to call for the updated case diary. TCR is otherwise there, but updated case diary as regards the further investigation, that has not come by.
You are appearing for the other side.
Yes.
So you need the updated one.
Yes, sir. We have not received that.
But your petitioner now facing the trial.
Yes, the trial has
Trial not yet.
not commenced in the sense, my lord, the other three persons, accused persons have not appeared. And in fact, the court has also not issued summons. That was one point which was pointed out, that the petitioner is being remanded, but summons were not being issued to the co-accused persons. Inadvertently, perhaps, my lord, for whatever reason, but summons were not issued. But in the
This
meantime,
was pointed out before the trial court, by someone.
my lord, that part I don't have instruction, but that in the meantime, the informant came and filed this petition for further investigation. So that was allowed. The other was a murder case and it has earlier been rejected by your lawsuit.
Here is the reason for non issuing the summons. The other three accused were the brothers of this present petitioner. Approach this honorable court by way of anticipatory application. This honorable court on the same day rejected and give them liberty to file appear before the learned trial court on 16/2 and till then not to take any coercive action. But they have not appeared till now and they are roaming in their vicinity. So therefore,
In
by
that way,
virtue of-
they violated that order also.
yes,
But even then, the court's duty of issuing summons would still remain, my lord, irrespective of the fact that these persons have not. Anyway, my lord will fix it.
Now
my lord.
see, the question is that corrosive action is different.
Yes.
And
Yes.
issuing summon is not in the basis
yes,
of that. case.
maybe magistrate
Because,
will give disorder.
Because corrosive action is what is that you bring
Yes.
issue NBW or bring on arrest or something.
Yes.
Unless and until he appears, no such corrosive. Let him appear. That was the in
Yes.
subject of the court.
Anyway, lots of
But,
up to date case there may be called for.
And next there is the trial court is 6/7/26 for report from the IO. Further investigation report.
That is fixed on 6/7.
6/7/26.
That would be a different thing, my lord. That is regarding the direction to the IO to submit final form. Because the trial court directed that within 3 months you file final form. That has not been done, so that further time has been given. But updated case there may be called for. Lordship may examine it independently, my lord. Lordship.
Hard Mr. Tesla till an constitutive petition. So DP Gusam till an additional PP bring on status. Mr. Estate. Till an council pay for the information. It is submitted by Mr. Gusam that this kind of copy of it was received. But as the case is still under further investigation, the case diary was called for. And the case diary which is received by the court received is not updated. In view of this, Mr. Husam submitted an updated case diary may be called for to know the present status of the investigation. In view of this, the IO is hereby directed to furnish the updated case diary along with the present status of the investigation and it present status and progress of the investigation. Yes, when it can be
17/6.
17/6.
Well,
Will do.
well.
17/6.
I'm deeply obliged.
Will do. 15.
15 lordship. This one is an interim. Case diary not received. Up to date case diary not received. Lordship. This one test poor.
Now, none appears on call for the Mr. DP Gusam and with additional people. And it is submitted that updated case diary is not received. Issue reminder. Yes,
18/6.
18/6. Interim be extended till next.
Taking also same pair lordship. This one is an interim. Case diary not received.
Case diary not received.
Not received.
None appears on call for the petitioner. Where it is submitted by Mr. Goswami that the C did not receive, issue reminder. List development can be
18/6.
18/6, interim be continued in next.
Look, as per order dated 28/1, 21, 26 only, your lordship.
26.
21 to 2026, my lord.
Acha.
This honorable court observed that, my lord, service upon the respondent, it is completed.
No, one order is on, I don't know, one order is on 21, last order.
No, last to last.
Last order, some
20
scope of settlement.
My lord, but it has not been done.
Oh,
Prior to that, my lord, 28/1/2026, there is an order. my lord.
28/1. Yes. Notice has been served.
Sir. In fact, this is
So
a case.
why it has been the last order, how it is last order is passed? There
My
may be
lord,
some
They,
information.
in fact, some talk was going on, but they didn't appear before this court, my lord. But that's why it
No,
was.
but the question is that it was submission from your side only.
It
You have
was
submitted a learned counsel for the petitioner has submitted that there is some scope of settlement.
settlement.
That is
In
the
fact,
submission was made by you then.
My lord, submission was made before this court,
Ah.
but there was talk between the settlement, my lord, but it was not materialized, your lord. Amount, because the amount which was fixed by learned trial court is 14,000. I am working as a driver, your lordship, and as per the judgment rendered by the Honorable Apex Court in Rajnish, your lordship will see. My lord, factors are required to be taken into consideration. My income, her status, and everything that has not been taken into consideration. In my humble submission, my lord, matter needs to be re-examined by trial court, my lord, in the light of the judgment of Honorable Apex Court in Rajnish, your lord.
So at present, is there any, you're making any payment or you're not taking any down?
We are making, my lord. We have paid, my lord, 2,19,500.
So monthly, how much you're paying monthly?
Not monthly, my lord. Whenever I am getting money, not regularly, I am paying, your lordship. Whenever some money is there with me, my lord, I am making her. Because, my lord, I have to take care of my second wife, her children, and children from first wife, your lordship. And
Children from first wife is with
no.
you?
My second wife, is, my lord, she was also married earlier. So one children was there. So I have to take care that children as well as my children.
Children from your second side,
My lord.
children from the first, husband of your second wife, you
My
are
lord.
taking care.
I-
But you're not thinking of your wife
I
and
am-
your children.
No children.
From first wife.
There is no. I have paid, my lord, 2,19,000. And in fact, I am paying. I am not saying I will not. I have to take care, my lord. But it has to be whatever income I am. My lord, I am driver, your lord. 9,000 income is approximate income is from my agriculture part, your lord. Approximately 9,000 or 10,000 I am earning from my that driver post, your lordship. So approximately 20,000.
Driver post me?
Not post. I am working as a driver, my lord. By doing driver job, my lord.
Do you think driver is earning only 9,000 per month this time at this day at this?
Lord,
Don't think so. If a
12,
private driver also you have to keep
12,000.
70.
If that is so, my lord, 12,000 or 15,000 maximum, not more than that.
So you have some agricultural property also.
My lord, that I have admitted and I have annexed that income certificate also. Approximately 9,000. So, learned trial court decided the matter, my lord, without taking into consideration my income and all, as well as her status, whether she needs 14,000. Because if I am giving her 14,000 per month, with me, my lord, I have to take care. Assuming my 25,000 I am earning, then 10,000 only will be with me. It is very difficult.
So, but at the time of this passing the order, your assets and liabilities for both sides were not considered?
But taken, but your lordship may kindly see the impugned order,
Yes.
page 40. And paragraph, my lord, three onwards, page 41.
Page 40, para.
Page para 41, my lord. Page para 3. This is my history, your lords. She prayed for 20,000. Only on the basis of statement, my lord. Para 7. Page 43. May I read, your lord? The statement made by the opposite party on oath shows that he is gainfully employed. He has also admitted that the Bolero car is standing in his name. He has stated that the said Bolero car was purchased with the help of loan facility. Availed. Has admitted that loan facility was given on his name. He has admitted that he has a bank account in Axis Bank. Though he has stated that the equated monthly installment against the loan facility are being paid by his elder brother. It is difficult to believe the same in absence of any cogent material substantiating the same. The above, even though it may not be possible to take statements of the petitioner as to income of the opposite party has gospel truth, it can easily be inferred that the opposite party is a person of sufficient means who can afford to provide reasonable maintenance to the petitioner and her son. As such, the opposite party is directed to pay maintenance 8,000 to the petitioner and another monthly maintenance 6,000 for his son, which he shall be payable from the date of institution of the instance proceeding. So, learned trial court, my lord, has not taken into consideration only on the basis of the statement and presumption, my lord. And that car, my lord, Bolero, was in fact taken by my brother, and now it had also already been disposed of, my lord. It has been sold, my
But it was standing in your name only.
my name, but it was given, an installment was paid by my brother. Ultimately, it was sold. Now, Bolero car is also not with me. What I am praying, your lordship, since your lordship from the paragraph 7, your lordship will see the learned trial court proceeded on the basis of presumption, my lord. That it cannot be inferred like that, oh my lord. But though no material as rendered by Honorable Apex Court in Rajnish Kumar.
But you have not adduced any evidence mostly for your
My lord, in fact,
your evidence
my lord,
only because date of evidence seems to be 2/6.
true, my lord.
The argument
I have given deposition to income. Yes. The page 17, my lord. Page 17, answer 1. This is a certificate issued by my government of Assam circle officer. So. This is certified that so, whose total income from business is 90,000 only.
you have received, but need to answer again. Can put it up.
Once
Scan
your,
copy was not called for.
my lord,
No, what I want to say that
Fine.
whether there was this SSN liabilities filed by both the parties or not, because we don't have the scan.
these are
copy here.
required, in fact, my lord.
Required
Okay.
because as you have submitted, most probably there may be some materials. Your liability you may have shown, but
Exactly.
at present before us there is nothing.
Nothing.
In this record. And if you go by the para 7,
It doesn't
seems
reflect.
that you have one Bolero car in your name, maybe by through
There
your
is no
brother, it
whisper
may
about my lord assets and liability and all, my lord.
be, needs, I think.
Need.
And if those were not, suppose that should be considered, but if it is not so considered, then there may be some direction or maybe remanded back to decide afresh. But at present, we have nothing.
So records in that case, records may be
The
necessary.
record will be required.
My lord.
See to it. Mr. It was the learned counsel for non-appears support for the response. From the order dated 28/01/2026, it is seen that the notice has already been served on the respondent, but no one has appeared or responded. A matter was taken up for consideration today, but during deliberation, it has come. It is seen that the perusal of the scan copy of the TCR will be required to know the assessment liability, especially to know the assessment liability submitted by the parties before the learned judgment. In view of this, that the scan copy of the TCR be called for, registrable to the input. It has to come from Borpata.
Barpeta.
It is
Court of Principal Judge, Family Court.
Family Court Borpata, 17th of this month,
17th of
June.
No, my lord, I shall be out of station. Can it be taken before 15 or my lord after 25?
We'll see. Before 15,
12.
12th of June.
Deeply obliged.
May I please, Your Lordship?
Yes.
My lord, by this application, my lord, I have challenged the proceeding as well as the order dated 21/12/2024, my lord. Taking the cognizance by the learned trial court, my lord. What happened, my lord? The complainant has lodged an
Just a second. You have challenged the order of
order dated 21/12/2024 along with the enter proceeding criminal complaint for the petition, my lord. The complaint case number 589/2024, my lord, pending before the judicial magistrate first class Kamrup, my lord. My lord, my lord, in this case, my lord, the complainant has lodged and filed a complaint case, my lord. Lordship will find that at page 25, Annex 1, my lord. Page 25, my lord, this is the complaint case, my lord, filed by them, my lord, where I have been inducted as the accused, my lord, sole accused, my lord.
yes.
My lord, kindly turn to page 26, my lord.
Hmm.
I am reading the paragraph 3, my lord.
Yes.
Paragraph 2, my lord. Very beginning, my lord, what happened in this regard, my lord, the accused person and the complainant has entered into a contract, my lord, by executing an agreement. So, as per that agreement, my lord, the complainant has handed over 2 night super buses, sleeper cum sitter.
Complainant.
Uh,
Complainant and handed over.
Yes, yes. On the strength of that agreement, my lord. That agreement is still in force, my lord. And my lord, I have to fly these buses, and as per the agreement, my lord, I have to pay the EMI on behalf of the complainant, since the complainant is the borrower against on the bank, my lord. And accordingly, what happened, my lord, some dispute arises between the parties, my lord. And thereafter, my lord, what happened, my lord, the present petitioner, the accused, stopped to fly the buses. He stopped to run the business, my lord. Whether the agreement was in exist. My lord, now, my lord, his grievance is that is at page 26, paragraph 3, my lord. That the agreement for flying 2 nodes of night super air conditioned sleeper cum sitter buses was executed between me and the accused person on certain conditions, and one of the condition of the agreement that is so and so was that the accused person will make the payment of monthly EMIs to the bank to my loan account and as the loan on the 2 vehicles. 2 nodes of night super air conditioned sleeper cum sitter buses were in my name, and so, my lord, he has showing some so the amount of the EMIs per date wise, my lord. And thereafter, my lord, paragraph 5, my lord. Paragraph 5 of his complaint petition, my lord, at page 27. That again, when there was a default in making the payment of the EMI for the month of July 2024, also, complainant tried to contact the accused person, but the accused person could not be contacted as the accused person is not responding to the complainant calls and he is not to be found in his last known address. at present whereabout the accused person as well as 2 nodes of night super air conditioned sleeper cum seater bus cannot be traced. Well, this is very important. 2 nodes of night super air conditioned sleeper cum seater buses cannot be traced by me as the accused person has disconnected the GPS devices of the buses which were installed by the Ashok Leyland company at the time of selling of the buses. This is his allegation, my lord, grievance. And paragraph 7, my lord. 6 also, my lord, he is given the some person of EMI's rate, my lord, which has been to be paid. 7, my lord. By this section, my lord, he is saying that I have committed an offense under section, my lord, under section 318(4) of the BNS. By this paragraph, my lord, he said it is a clear indication that the accused person with a malified intention of cheating me have executed the agreement and also with an intention of illegal gain by committing fraud on the complaint. This is his first allegation. And second allegation is that, my lord, paragraph 8, that it is also the fear of the complainant that as the whereabout of the 2 nodes of night super air conditioned sleeper cum seater buses could not be traced, the accused person might have sold the 2 nodes of night super air conditioned sleeper cum seater buses outside the state of Assam. That means that is a breach of trust, my lord. That is the entrusted property I have sold to anybody else, my lord. But in fact, it is not correct. After that, my lord, this statement is valid up to the 21, my lord. On 21, what happened, my lord? 21, my lord, the matter was placed before the trial court, my lord. On that day, my lord, trial court has taken the cognizance, my lord. Kindly turn to that page. Page 33, my lord, Annex 2. I am reading, my lord. My lord, I am reading from the paragraph 3, my lord. Of this order, my lord. 21/12/2024. This is my impugn, my lord. I am challenging it. Upon examination and on perusal of the petition, I have found prima facie materials against the accused person, so and so. Hence, the cognizance is taken of the alleged offense under section 314, 316(2), 318(3), and 318(4) of BNS. That means, my lord, togetherly cheating and criminal breach of trust. And last paragraph, my lord. Later on, the complainant has appeared again with one of his witness, PW1, is examined under section 225 of BNS. Hence, upon examination, I am satisfied that there are sufficient ground to proceed against the accused person. Issue summon to them accordingly. The summons shall contain a copy of the complaint as mandated under section so and so so and so. Further, the complainant had filed a petition vide number so and so paying to issue a search warrant against the accused person for recovery of 2 vehicles bearing number so and so so and so so and so. Complainant is directed to furnish a service copy of the petition to the accused person. And accordingly, my lord, he has filed another application for amend the complaint petition and search warrant. And my lord, then my lord, kindly turn to, my lord, I am coming to the agreement about the agreement later on, my lord. That is Annex 3, my lord. But what he has witnessed, he has deposed his witness. That is lordship will find at page 42, Annex 4. Very interesting, my lord. In paragraph 7 and 8, he has said, I have sold the buses to outside of the Assam. And 7, he has said, I have the bad intention to enter in the execution. But he has made the statement before the court at the time of the taking cognizance. What he has said, my lord, by taking oath, my lord. I am the complaint, I am reading his statement. I am reading the complainant in the case on 18 March 2024. I entered into an agreement with the accused person that he will make payment on a monthly EMI of 2 nodes of night super air conditioned sleeper cum seater buses against my loan account having an amount of rupees 9 so and so from July 2024. The accused has defaulted paying EMIs. My lord. This is the grievance, my lord. And other payment according to the agreement now. According to the condition of the agreement, if the accused fail to pay the EMIs and the other dues, he was supposed to return the buses to me, but he had failed to do so the same. And now one bus is having registered on number so and so is laying in bay 20 of ISBT. Immediately, my lord, he become to know about the bus, existence of the bus. ISBT Gauhati and the other one having registration number 1439 is nowhere to be found. Further, the GPS tracker in both buses have been removed. The insurance of both buses will expect. That is another thing. And another neutral witness also examined on that day, my lord. He has said what, my lord? This is the self-contradictory, my lord. That that is Annexure 5, my lord, at page 44. The complainant is my neighbor. When the complainant entered into an agreement with the accused person on so-and-so, at Gauhati, I was present with the complainant. Thereafter, 3 months of EMI was paid. 3 months of EMI was paid by the accused, but after that, he defaulted paying the EMIs and other dues. Now the buses are also not running and nowhere to be found. The complainant tried to contact the accused multiple times, but it was no avail. Hence, I suggest him that he should file complaint case in the court seeking relief. And his amendment petition, my lord. In the amendment petition, he said what said, my lord. In amendment petition, my lord, he paying for the interim relief, my lord. That amendment petition, lordship will find at page 45, Annexure 6, my lord. And my lord, this amendment petition was in the time of the taking the cognizance. Court has not decided on that day, but agreed that he himself challenged that order, my lord, before the session judge, my lord. Session judge, that is lordship will find at page 52. Session judge again returned back it to the trial court, my lord, for final consideration at the early stage, my lord. At the time of filing of this case, my lord, that case was not cleared, my lord. That's why I have annexed this for all the order later on, my lord. My lord, in the complaint revision petition, my lord, the order I have annexed herewith. In the revision petition, my lord, lordship kindly turn to page 66. The session court observed that it is seen that the next date fixed for hearing for the complaint petition, that is at 66 page 66, my lord, para 5, my lord, I am reading. It is seen that the next date fixed for hearing of the complaints petition is fixed on 5/4/2025, which is just 10 days away from the today. And therefore, instead of deciding in the instant revision petition on the merit maintainability, I deem it fit to dispose of same with a direction to the learned JMFC Kamrup Metro to hear and dispose of the petition number so and so. That is the amendment petition of the complainant as expeditiously as possible and without any further delay. And accordingly, what happened, my lord, I am coming later on, my lord. In the paragraph 11, my lord, I have made the payment sum. Annexure 11, page 67, my lord. I have annexed the bank statement. This is of my account, my lord. I have transferred the money. Lordship will find at serial number date, term date, 14/3/2024, my lord, 2 lakhs, 18/3/2024. 3,50,000. And accordingly, my lord, I have making the payment from the beginning to another 4 or 5 months, my lord. In the month of August, the dispute was arises. And I have, as per the agreement, I have followed everything, my lord. Tax, I have paid, I have annexed the document at paragraph and as annexure 12 series 75, page 75. And I have also given a notice to him, my lord. Legal notice, my lord, to settle the matter. That notice was served on 18 November 2024, my lord. That is, lordship will find at page 82, annexure 13. But in the meantime, my lord, he approached the court, my lord. My lord, in this regard, my lord, I have filed an additional affidavit, my lord, to bring some record after during the pendency of this case. My lord, in that case, my lord, that is filed on 15/11/2025, my lord. Additional affidavit, my lord.
Yes.
paragraph 4, my lord, at page 88, my lord, of my additional affidavit, my lord, that the petitioner, deponent, accused most respectfully begs to submit that after passing the order dated 11/4/2025, the bank authority has taken the custody of the bus by registration number AS01QC21, which was unknown to him, my lord. Which was unknown to him as per his statement, my lord. My lord, actually what happened, my lord, kindly turn to page 93 of the order, my lord. The amendment order, the trial court has decided the case, his amendment petition on 11/4/2025, my lord. That is at page 91, my lord. And relevant portion, my lord, I am reading, and that is at page 93. However, from the prospective consideration of the petition and the objections, it is seen that the whereabout the buses showing AS01QC1521 is already known to the complainant that it is laying in the bay number 20 of ISBT Gauhati, and as per the order dated 5/4/2025, the complainant has also confirmed that the bus bearing number AS01QC1439 is already seized by the State Bank of India, which is now a matter that the complainant has to resolve with the bank. There is no any criminal breach of trust, my lord. There is no sitting, my lord. That is the facts, my lord. This is not my statement. That is the court observation, my lord. And accordingly, my lord, his later on, my lord, by this order, my lord, the learned court below denied to amend the petition, my lord, and dismiss his complaint amendment petition. And in this case, my lord, the petitioner, the complainant, the respondent did not file any response to this complaint petition, but he has filed an IA, my lord. And this IA he is going to place as in his objection, my lord, as in his defense, my lord. In the IA, my lord, lordship will find that IA 716/2025, my lord.
What is I? I
IA for vacating my interim order. I am in the interim protection, my lord. Your lordship.
file.
Lordship?
No.
IA
or-
has been filed by him, my lord.
Yes.
He has not filed any objection, my lord.
So we are going to dispose. What is the term?
No, my lord, no, my lord, I am coming to that. My lord, he is he is depend on this IA, my lord, as his defense, my lord, in the case, my lord. That's why, my lord, I am just relying in this order, my lord. In that, my lord, I am not reading everything, my lord. He will read everything, my lord. In this IA, my lord, I am just trying to show some relevant paragraph, my lord. In that, my lord, in IA, paragraph 7, my lord, page 5, that the applicant is not narrating the entire list of the event herein for the purpose of the brevity and keep the liability of this honorable court to rely on the facts narrated in the complaint filed before the learned judicial magistrate. Further, the petitioner herein has himself admitted that he has handed over the bus to the collection agent, my lord. The bus has been seized by the bank authority from him, my lord, and from him, he will place before your lordship. But in this regard, my lord, I have filed my reply, my lord. Lordship, I have filed this reply on 29/8/2025. Actually, what happened, my lord? Kindly turn to page 55 of my reply, my lord. Annexure 1 in IA, my lord. This is the seizure notice, my lord. This seizure notice was issued on 16/11/2024 by the bank authority to the complainant, my lord. Bimal Thakuria. Of 2 buses, my lord. And my lord, after that seizure notice, my lord, turn to next page, my lord, 56, 12/2/2025, my lord. The bank authority has taken the custody of that bus, height bearing
Seizure
number, my
notice was issued to whom?
Bimal Thakuria, the
Exactly.
complainant. That is at the top of the notice, my lord.
Acha.
Srimati Bimal Thakuria, flat number so and so, Syndicate Arena New, Sosol, VIP Road, Gauhati. That's the top of the list, my lord. State Bank of India, that notice was issued. And next page, my lord. This is the this is the letter, my lord. This is the receipt of seized the vehicle, my lord. This vehicle has been seized from the custody from the Bimal Thakuria, my lord. This is admitted and this was disclosed before the trial court. This is the notice, my lord. 1439, first number, that has been seized. And another bus is in the lane number 20, my lord. And now, my lord, the question is that, my lord, the court has taken the cognizance togetherly under section 316(2) and 318(4), criminal breach of trust and cheating, which is not maintainable. Togetherly, in a same case, one person cannot commit offense, both the offense in the same case, my lord. In this regard, my lord, Honorable Apex Court, my lord, observe that, my lord, Delhi Race Club, 1940 Limited and another. This case totally covered by it. This is reported 2024 ARSC Criminal 1369. Now, this order has been passed by Honorable Apex Court on 23/8/2024, prior to the impugn order. Impugn order has been passed. Impugn order was passed 21/12/2024.
And this order?
This order was passed, Lordship, that is there, my lord, decided on 23/8/2024. That is the more edition. My lord, here, my lord, I am reading the relevant portion, my lord. First, my lord, turn to page 15, my lord.
Page
15, my lord, of this judgment, my lord. Para 24, my lord. By this para, my lord, the Apex Court relied a judgment reported in 2002, 1 SCC 241, where it was distinct. It was made distinct between the two sections, my lord. The ingredients were discussed, my lord. And in respect to this paragraph, my lord, the Honorable Apex Court in the Delhi case has been considered at same page, para 25. Next para. What can be discerned from the above is that the offenses of the criminal breach of trust, section 406 IPC, and cheating, section 420 IPC, have specific ingredients. In order to constitute a criminal breach of trust, section 406, number 1, there must be entrustment with the person for the property or dominion over the property. Number 2, the person entrusted, A, dishonestly misappropriated or converted the property to his own use. This is absent in my case. Dishonestly use or dispose of the property or willfully suffers any other person so to do the violation of Roman 1, any direction of law prescribing the method in which the trust is discharged. Roman 2, legal contract touching the discharge of trust, so and so, so and so, so and so. 26, my lord, paragraph. Further, in both the aforesaid section, mens rea, that is intention to defraud or dishonest intention, must be present. And in the case of the cheating, it must be there from the very beginning or inception. Very beginning and inception. In the their witness, it is admitted that up to 4 months there is nothing and the property has not been used. Both the property known to him, what are the existence of that passage. And paragraph 27, my lord. In our view, the plain reading of the complaint fails to spell out any of the aforesaid ingredients noted above. We may only say, with a view to clear a serious misconception of law in mind of the police as well as the court below, that if it is a case of the complainant that offense of criminal breach of trust as defined under section 405 of IPC, punishable under section 406 of IPC,
is committed by the accused, then in the same breath, it cannot be said that the accused has also committed the offense of cheating as defined and explained in the section 415 of the IPC, punishable under section 420 of IPC. This is a totally, my lord, this order, impugn order is totally void, my lord. Totally void, my lord. According to this order, my lord, that order has been passed by the trial court without application of my lord. And 28, my lord. Every act of breach of trust may not result in a penal offense of the criminal breach of trust unless there is a evidence of manipulation act of the fraudulent misappropriation. An act of breach of trust involves in a civil wrong in respect of which the person may seek his remedy or damages in the civil court. But any breach of trust with the mens rea gives rise to a criminal prosecution as well. It has been held in the Hariprasad case, so and so, my lord. Hariprasad case was discussed. And para 29. Para 29. To put it in other words, the case of cheating and dishonest intention start with the very inception of the transaction. But in the case of criminal breach of trust, a person who comes into a possession of the immovable property and receive it legally, but illegally retain it or convert it to his own use against the terms of the contract, then the question is, in the case like this, whether the retention is with the dishonest intention or not. Whether the retention involves criminal breach of trust or only a civil liability would depend upon the facts of the each case, my lord. That's why, my lord, I am saying his case, complaint case, is not maintainable because it's the case of the civil liabilities. Under section 7, he can file a case under section 7 of the specific relief act before the civil court, my lord. And this is the paragraph 30, my lord. The distinction between the mere breach of contract and the offense of criminal breach of trust and cheating is fine one. In the case of the cheating, the intention of the accused at the time of the inducement should be looked into, which may be judged by the subsequent conduct. But for this, the subsequent conduct is not sole test. Mere breach of contract cannot give rise to the criminal prosecution for cheating unless fraudulent or dishonest intention is shown right from the beginning of the transaction. That is the time when the offense is said to have been committed. Therefore, it is this intention which is the gist of the offense. Whereas for the criminal breach of trust, the property must have been entrusted to the accused or he must have dominion over it. The property in respect of the which the offense of breach of trust has been committed must be either the property of some persons other than the accused or beneficial interested in or ownership of it must be some of the person. The accused must hold the property on trust of such other person. Although the offense, that is, the offense of breach of trust and cheating involve dishonest intention, yet they are mutually exclusive and different in basic concept. There is a distinction between the criminal breach of trust and cheating. For cheating, criminal intention is necessary at the time of making a false or misleading representation, that is since inception. In criminal breach of trust, the mere proof of entrustment is sufficient. Thus, in case of the criminal breach of trust, the offender is lawfully entrusted with the property and he dishonestly misappropriates the same. Whereas, in the case of cheating, the offender fraudulently or dishonestly induce a person by deceiving him to deliver any property. In such situation, both the offense cannot coexist simultaneously, my lord. That means, my lord, one case, the court cannot take the cognizance under section 420 and for cheating and criminal breach of trust. What is the outcome of this case, my lord?
Okay, we pass on.
All right. That is 42, 43, and 45, my lord. This is the findings of this court, my lord. And
Yes,
in
there are other judgments also wherein
yes,
it
my
says that both
section cannot
cheating and misappropriation cannot come together. There are
together.
many others.
That is the case, my lord. And accordingly, my lord, 45, the impugn order passed by the High Court set aside. So also the order passed by the additional chief judicial magistrate, so and so, taking cognizance upon the complainant. My lord, that was set aside, my lord. In this regard, my lord, this case, my lord, the complainant case, the complainant filed a complaint under section, my lord, under section 316.2, 318.2, 318.3, 318.4, 314, 303, 351 of BNSS. That is meant, my lord, sittings and sitting and criminal breach of trust, my lord. And from the plain reading and the further development of the cases, my lord, it was come to the light that there is no any ingredients, my lord. His offense, his grievance is only the buses, both the buses, my lord. Now, my lord, the second bus, which was standing in the bay number 20, my lord. From my inquiry, my lord, I become to know, my lord, that bus also has taken the custody by the bank authority, Polton Bazar branch, my lord. I have stated in my additional affidavit, my lord. And my lord, now, my lord, the question is that, my lord, whether the cognizance order dated 21/12/2024, my lord, is totally not maintainable, my lord. So the cognizance order is not maintainable in the eyes of law, my lord. The entire proceeding pending before the trial court, my lord, judicial magistrate first class may be set aside and quashed, my lord. In this regard, my lord, another judgment also passed by the Honorable Apex Court, my lord. That is small item, my lord, similar on the basis of in the light of that Delhi race club, my lord. That is, my lord, only paragraph 21, my lord. And same case, my lord. That is also under section 406, 420, and 120B, my lord. That is only paragraph 21, my lord. That was decided on September 24, 2025, my lord. After 1 year back, my lord. This is my case, my lord. And this is my pair, my lord. Kindly set aside the impugned order, my lord, and accordingly the pending criminal proceeding before the trial court may be set aside.
Yes.
Maybe, Your Lordship. Lordship, the stage at which the petitioner has come for this honorable court is the stage where the summons has been issued. First, as per the new BNSS, a pre-cognizance summon was required to be issued, which was not present at the earlier CRPC. So they had pre-cognizance stage, they had come, they had argued the matter regarding being satisfied that there is some materials cognizance was taken.
Pre-cognizance hearing was there.
Yes, that is it, because they have, it is not a, because Lordship may look at it. First, the complaint was filed on 5th September 2024, which is at page number 32. Then summons were issued. They had appeared. They had sought adjournment after 2-3 dates. The hearing took place. Now, what had happened is that the initial stage when the complaint was filed, I was not the counsel there, and I saw that there was a specific statement in the complaint petition, but there was no prayer for a search warrant. So I had advised that there should be a prayer for search warrant because we know where the vehicle is. Because first, what has happened, 5th September, the chronology of the whole event has to be understood. 5th September, there is a complaint. Cognizance steps are taken. What they do is that on 18 November, they give a legal notice. After the case is filed and after they appear, they give a legal notice to that effect. And the cognizance was taken on 21/12. Now, 21/12, on the date of taking cognizance, the learned magistrate below was pleased to issue notice on this search warrant. No decision was made to that effect. Now, as it went ahead, finally, as the buses were recovered, the whole idea of search warrant is redundant. Because the search warrant is, why was the search warrant sought for? It was sought for both the vehicles were not known to me. This is a specific statement in the complaint petition. When there is a specific averment to the effect that it was not known to me, that aspect of the matter, whether it will be adjudicated at this stage or at the trial stage. That is the first part that has to be looked at. Because at this stage, in my respectful submission, this court has to look whether there is a prima facie case. Now, the aspect of prima facie case cannot be gathered anywhere from outside. It has to be gathered on the materials on record and what is the complaint saying. Here in my complaint petition, which is annexed at page 25, paragraph 5, it has been read. The specific line that I have said is that complainant tried to contact the accused person, but the accused person could not be contacted as the accused person is not responding to the complainant's call and is not found in his last known address. At present, whereabout of the accused
No, it
person
is
is
where you have
page 27 of my
27.
27 of his of the criminal
Okay.
petition.
Yes.
That again, when there was default in making the payment of the EMI for the month of July 2024, complainant tried to contact the accused person, but the accused person could not be contacted as the accused person is not responding to the complainant's call and he is not found in his last known address. At present, whereabout of the accused person as well as the two numbers of night super air-conditioned sleeper cum seater buses cannot be traced by me as the accused person has disconnected the GPS.
But subsequently, when you have come to know that your one bus is lying in the bay line of
When it was lying in the ISBT, there was some known person in the ISBT confronted, is this your bus? Then I went and so I came to know, when I came to know, I gave up. On 5th September, there was no. And Your Honor may look at his legal notice, the language he uses, which is clearly, it is legal notice page 83. Page 83, he has annexed that my client is now had to suffer mental and physical harassment for which he is going to hand over the two night super bus to you as he has suffered grave loss in respect of the two night supers. This is an admission that it was in his custody, which I had asked, but he is not giving. Why he is not giving? The amounts to be refunded to my client is such and such only. Now, at the request of my client, request you to refund the said amount of such and such only within a period of 15 days. And after the receipt of the total amount of 1 crore such and such, only my client will hand over the two vehicles to you. Is he the registered owner? Was there any authority to keep that vehicle? Now, this will be adjudicated in the trial. Whether at this stage, now this is his legal document. How it gets with this, all these factors will come in the trial. He is saying that I will not give you the vehicle until unless you give me the money. Now, was he the rightful owner? Does it not fall squarely under the criminal breach of trust? Regarding the part whether criminal breach of trust and the 318, 316, whether it can go simultaneously. Here in this is a peculiar situation. Now, every fact has to be understood. Every case has to be understood in the given fact. Here it is a peculiar situation. His legal notice, if we read, he says, page 82. He says I just read his legal notice for the clarity of his mind. That page 82 it starts that on 18 March 2024 executed as a registered agreement with my client before the notary public for applying two night super air conditioned sleeper buses made Ashok Leyland Limited Model TF such and such, which buses were allowed to continue from such and such to such and such. Signature of the advocate through when you drafted was not given in the said agreement. You requested my client to pay such and such as a lump sum amount in respect of the two night supers, and accordingly, my client paid you the said amount through such and such, such and such. Now, these are the payments he made. As per agreement, you requested my client to pay monthly installment. Accordingly, my client has already paid 3 installments in respect of the night super through Axis Bank. Next page. My client did not know what were written in your agreement. I pay 10 lakh rupees. I pay 3 EMIs. Now the question is that whether there's a case where he was initially thought that he could take away the buses or whatever is the intention, how it will be asserted in the trial. At this stage, I'm not. Whether these things can be ascertained here at this stage, whether a prima facie case has been made or not. Prima facie case, whether it will be 318, now it is a pre-cognizance. After that, charges will be framed. Whether the charges will be framed under both the sections and then
there is an illegality that can be there. There's an illegality. Yes, both these sections cannot run together, which I'm not submitting to the fact that it can run together. It's contrary to the aspect of it. That I'm not giving a submission that just for making a submission. That is there's a judgments are there. It's a fact that it cannot go because here initial deception is here entrustment is there. Now we have to look in the given facts and circumstances. Here we have to understand that that part has to be there, whether the initial deception was always present or not. That would be at the when the charges will be framed. At the time of framing charges, they will make a hearing, they will do a charge hearing, we will say our part, and the magistrate will give an order to the effect what charges will be framed. And then they have a recourse that they can again come back to know that magistrate was patently wrong in framing this charge and XYZ charge. At this stage, when they were represented, whether there exists your lordship has to look whether there exists any prima facie material or not. In my respectful submission, the point is that just the two paragraphs that I have read and the legal notice which is attached and which they have also read, prima facie, in my complaint petition, the prima facie case has been made up. Here I am not saying that I had known that vehicle he has sought to place before this honorable court my deposition. My deposition was taken on 21/12/24. The vehicle, when I came to know about the vehicle, I will obviously depose correctly before the honorable court. I will not lie before the honorable court saying that no, the vehicle is not recovered. When I came to know, because after filing the sequence of event, he has the intent of committing the offense of either criminal breach of trust or 318. That would be but he had an intent of doing that. He intended to defraud me. That's why the moment 3 lines, the moment I have been trying to contact him, he does not contact me. On the contrary, when I filed a case, he gives me a legal notice saying that if you give me the money, only I'll give you both the buses. That's his own admission. And this is before the third, regarding the aspect which says that it is us only who has taken the vehicle, and to that aspect, it is their document which they said. This is to be disputed, which is at page 56, which your lordship have been shown. It is received by one Rajiv Gogoi. Now, who is this Rajiv Gogoi? I'm not aware. I am not received. It is addressed to me. Am I a name of the person customer surrendering the vehicle? It is Rajiv Gogoi. Am I Rajiv Gogoi? So what it does is that when he comes to know about it, the bank is looking about the vehicle. So he involves the bank. You take away this vehicle. Now, the thrust of the whole argument is that this is a civil dispute. This is a civil dispute to the effect. Now, civil dispute regarding the recovery of money, that is different. Supreme Court in various judgments have been continuously saying that no, you cannot give the color of a criminal proceeding to a civil dispute. There is no quarrel to that effect. But it has also said in various judgments that both the proceedings can go. Question: the civil aspect is different here, the criminal aspect is different. What is this criminal aspect? First, he does is that he goes, there is no communication, he does not even bother to reply to my thing. Second, when I file the case, he gives me a legal notice and he gets in touch with all these people or the bank people, and now I ask myself this question, your lordship, both the vehicles are where with him. When I'm saying I have not got the vehicle, which is on oath, how the vehicle will go on its own to the ISBT? What prevented him from not delivering the vehicle to me? The vehicle could not have gone on its own to ISBT. So that was his intent. He kept the vehicle in the ISBT. The tires were taken off. What are the other things that has been taken off from the vehicle? Now the bus. The bus consists of many other factors. It's not just the bus. There are tires, there are engines, there are things. Now the State Bank has taken over the position. They are making an assessment. They had made an assessment letter to that effect. That would be produced before the trial, saying that, see, we had given the whole bus. Now, who took away, if the seat is not there, if the tire is not, these things will come in the trial. Whether at this stage, your lordship will intervene in this,
intervene in the proceeding and dismiss the proceeding on the fact that there is no ingredients. Prima facie, there are ingredients in my. I'm not going to trouble your lordship by going through it. I only needed to show there is a prima facie case. In my respectful submission, there is a prima facie case. It is not at all a fit case for quashing at this stage. The charges will be taken. After that, he has all these arguments can be made in a trial. No, this is done this way, that way, or whatever. That the option is there. It is not that he has been convicted. The conviction that he said, no, he has said in this trial, in this statement is this statement is this, and that statement is that. If there is some contradiction, he can take advantage of it during the trial. Whether at this stage it can be. Now, just one judgment, I'll not bother with law of judgment. There is this Supreme Court judgment. Copy it. AR 2025 SC 3316. Kathianini versus Siddharth PS Reddy.
Just repeat this as AIR.
AR 2025 SC 3316.
Yes.
Just paragraph 23 clearly says, I'll just read for logic. Read. The above precedents set by this court make it crystal clear that pendency of civil proceedings on the same subject matter involving the same parties is no justification to quash the criminal proceedings if a prima facie case exists against the accused persons. So,
Yo, which one are you reading? 23.
page paragraph 23.
23.
23. Paragraph 20. Page 9. All that has to be looked into it is that whether there is a prima facie case. The complaint petition has to be perused. The petition which has in the complaint petition whether there are statements and averments which needs adjudication by this court. I've shown the reply petition, the legal notice that has been replied, and regarding the other aspects, whether who, if this thing has to be looked into it, whether at this stage these things can be looked into it. These are a matter of trial. This Rajiv Gogoi is my person, assuming for a moment. So this will be proved in the trial. See, it's you only, your person, Rajiv Gogoi only, who is there, and you have instructed this. It will be proved in the trial. Whether at this stage it can, because prima facie it is saying Rajiv Gogoi. In my respectful submission, this is not a fit case for quashing, and the instant petition ought to be dismissed.
My lord, here, my lord, I have to clear 2 points, my lord. He now rely on my legal notice, my lord. In the complaint petition about the legal notice is absent. And the time of the taking complaint.
No, he is saying on that. Your legal notice was after the complaint, not before.
No, my lord, 18 November, I have served the legal notice. I have received
18 November of 2024.
24.
That's what I'm
Yes,
saying.
at that time, my lord, the complaint I have submitted, my lord, earlier. At that time, they have filed the complaint petition.
Yes. You just filed the complaint petition in September.
And that has not come to the notice before the trial court. That was not brought to the notice before the trial court by the complainant about my legal notice. And in the meantime, my lord, I have not been served the summons. I have not received the summons. I have received, after receiving the summons, my lord, on 17/12, I have appeared before the court. I have appeared before the court, paying some time since the accused could not come on that day. And accordingly, my lord, after 4 days, on 21/12/2024, my lord, court has fixed the date and accordingly taken the cognizance.
But if the court says that both the parties were heard extensively.
Present, my lord. I was present, my lord. On that day, my lord, I have submitted.
No, you were heard.
Yes. Yeah.
On 21/12, at the day of taking cognizance, pre-cognizance notice was already there and it was heard.
My lord, court has observed it like that, my lord. My lord, on that day, my lord, some other advocate was appeared. I was not appeared, my lord. They have submitted something, my lord. But that was not accepted on the basis of his statement, my lord. On the basis of his statement and materials available before the trial court, my lord, and the statement
It's okay.
of
Basis
and
now,
my lord,
see, now the
and-
complainant.
no, my lord, my submission, my lord, on that day, my lord, cognizance has been taken in that two particular in the 4 section, my lord, for 340.
No, I'm not on that. I'm
Oh.
just asking you. Because pre-cognizance notice was issued, you appear to come back.
No, my lord,
It's okay.
in presence of
then on
presence of the
21,
accused
12
person, my lord, the cognizance has been taken, my lord.
On 21/12, you were heard.
Extensively, the word
You
is.
were heard. Word extensively is used. That means
My
you
lord,
were heard.
that is mentioned in the impugn order, my lord. That is mentioned.
Whatever. We are not there. You are also not there. I'm also not there. But the question
That is
is that
mentioned in the impugn
it
order.
was heard.
Yes,
In
ma'am.
your presence, after pre-cognizance notice was issued and pre-cognizance hearing was taken up. Obviously, at the time of pre-cognizance notice, the complaint and the statement made by so and
madam,
so
that
is
is
to
not
be heard, or
Yes.
it should be taken into consideration. So that was considered.
Yes, madam.
But in your presence, it was heard.
Yes, madam.
So I am not on the other merits of the case.
Yes,
I'm
madam.
just asking because cognizance.
Yes,
was
madam. That
taken
is
into
reflected in the impugn order, madam.
Yes.
Yes. Madam, I am that and another submission, Rajiv, yes, no, some name of the person, my lord. Rajiv. কি নাম কলা? Rajiv Gogoi, my lord. In this regard, my lord, kindly peruse again, my lord, the trial court order in the amendment petition, my lord. 11/4/2025, that is started in my reply, my lord, to his IA, my lord. That is at page 57, my lord. There is a relevant portion at 59. However, from the conspectus consideration of the petition and the objection, it is seen that where about the bus bearing number A01QC 1521 is already known to the complainant that it is laying in the bay number 20 of ISBT Gauhati, and as per the order dated 5/4/2025, the complainant has also confirmed that the bus bearing registration number so and so is already seized by the State Bank of India. My lord, this is not confirmed by me, my lord.
See what I'm saying. Obviously, there's an order.
Yes, ma'am.
And in the order itself, the court observed that those buses were already been seized by the State Bank of India. No doubt about it. This order was filed in regards to the amendment only. Because on that day itself, they made another prayer for issuance of a such warrant.
And some other.
On that day, most probably the buses were not there. But the question is that subsequently buses were there, those were seized by the State Bank of Authority and it is sealed. So considering these aspects, the subsequent prayer for amendment was rejected by the court.
Yes, ma'am.
That is there.
That is enough, madam. He has raised this question. That's why, my lord, I clarify it. He raised that some other person has been name of the Rajiv Gogoi.
Rajiv Gogoi, Caesar is from Rajiv Gogoi.
From his custody.
Why you
I
are
don't
uttering
know.
the name Rajiv Gogoi? Caesar is from Rajiv
Name
Gogoi.
and signature of the.
Caesar is some Rajiv Gogoi's main.
Well, I don't know, my lord. Who is he?
And the question has to be understood that when this order has been read, this order says complaint has already been seized by State Bank. Am I saying that
No, that is.
it has been taken? No, that what will come. That is now if that am I saying is this order saying that it has been seized by State Bank by me, from me, from me. Does this order the facts that he is saying? I am not disputing the fact that it has been seized. I have submitted already. 5th September, I have filed a case. He gives a legal notice. That legal notice is a part of the record. If the record is called for, they have filed in the objection. It is part of the record. It is there in the record. If this is a statement, I'm giving it responsibly. So the second part is that the aspect that he is saying that I am nowhere saying that I'm not saying that it is not seized. What's a fact is a fact. Now, question is at the time of filing this complaint petition, whether any act, omission or commission of any act which will be an offense under the BNSS has been committed or not. That is the aspect which has to be looked at. That's what style is about.
Of
That's my respectful service. Deeply obliged.
My lord, that is intimidated. My lord, my sub
Ah.
My-
10th of June, Lordship will pass an order. I will be
CID,
out
my
of
lord.
station. Will I be required? I'll be out of station on 10th of June.
Only judgment will proceed.
12.
Delivery of judgment
Anyway,
on-
I'll depute some unit. Delivery order.
No, 313, my lord, court will be raised, my lord.
So,
Not 10th of June, 12th of June. 10th of June, my lord, so many cases I already been treated.
same thing, no? The order will be passing. We have not
Only order will be
Ten-
passed. Yes,
ten-
delivery of order.
Very that
Yes,
delivery order. 10th of June, 10th of June.
Madam, my humble submission is that is on rely on the judgment of Delhi Rescue Club, madam. That is only the case, madam, since he is saying facing the trial, madam. In this case, madam, where the cognizance on order as per the apex court observation is not maintainable, the further proceeding of that or is not maintainable, madam. That is my submission, my lord. Okay, this is my case, my lord. And his submission is then in that judgment. That is another case, my lord. There's just parallel proceeding, my lord. Civil case and criminal case, my lord. Thank you very much. 10 last week.
Yeah.
In the meantime, my lord, in time may be continued, my lord. Yes, my lord. This close.
Economic. Enter order. Deeply obliged.
Please, your lord.
I don't take much time. Issue is very small here. Lordship will kindly see here we have challenged the impugned order that is in page number 106, annexion number 7, Lordship. What has happened, Lordship, in a FC criminal case for maintenance, Lordship? Order has been passed, final order has been passed, Lordship, whereby the present petitioner before Lordship was directed to pay maintenance to the amount of 13,500. Now that amount he is already paying. He is paying, he is regularly paying. And an arrear accumulated, Lordship will kindly see that arrear accumulated to 5,70,000. Now in that respect, we filed a petition that considering his present condition, present financial condition, he is a retired person from army, Lordship. And he has his old parents who he has to look into. So he filed that part, Lordship will kindly see, that is in page number 132, Lordship may kindly have a look, Lordship. 32. After hearing both the parties, the second party is hereby directed to clear the arrear maintenance of rupees 5,70,000. Your Lordship has kindly find it, Lordship. 5,70,000 in 3 equal installment commencing from 18/11/2025. So he filed a petition before he addressed the Honorable Court that it was not. Yes, Lordship, it is the same order only. It was an extensive order, the final order, in fact. Final order. Now he said that it was not possible in his part to pay 5,70,000, and therefore he approached this Honorable Court. Now this Honorable Court, Lordship, will kindly find this Honorable Court, wide order dated 9/12/2025, passed that no coercive measures be taken against him. And in the meantime, Lordship, he has already paid 2,31,000 out of this 5,70,000. And 13,500 he is paying monthly. Now, already he has paid, if 13,500 is considered, then 3,13,000 and 3,12,000 he has already paid. That I have filed one additional affidavit and I have brought on record. Out of 5,70,000, Lordship, out of 5 lakhs. No issue in that. Including the maintenance. And out of 5,70,000, Lordship, 2,31,000 has been paid by him. 2,31,000 has been paid by him. Now, Lordship, the crux of the issue here involved that while going through the entire judgment that starts from page 106, Lordship will kindly see that Lordship knows well that in assessing this judgment, assessing this maintenance, Lordship, as per this Rajneesh versus Neha's judgment, I have already given the judgment. It's a very long judgment. Copy is already there on the record. I may share with your Lordship one. Even then, one copy I'm having, Lordship will kindly find the guidelines in number 4. It says that assets and liabilities is required. Number 4 guideline, Lordship may kindly have a look, Lordship. Now, going through the entire impugned judgment, it is very clear that this assets and liabilities was not taken from me, and it was perhaps also not taken from the petitioner out there. So, Lordship, it requires a reassessment if I am not wrong. A reassessment is required by asking the parties to file their assets and liabilities. Although I am paying as per this Honorable Court's order, but I feel that as per this Rajneesh versus Neha's judgment, the assessment has not been done properly, Lord, because the assets and liabilities were not taken into consideration. That is only the limited scope of this revision that I have filed before your Lordship. Otherwise, leaving me aside voluntarily, those aspects are there. I am not entering into all those aspects because some aspects we have not been able to prove some aspects as per this Honorable Court's order, and they have also not been able to prove certain aspects. So I am not touching those aspects. One thing, Lordship, I could not find out from the entire impugned judgment whether this court have looked into the assets and liabilities. So if it has not been looked into, I think no prejudice will be caused if it is for that particular purpose only for that limited purpose, if it is referred back for the reassessment again. And TCR was also called for. I also could not find in the TCR.
Nothing.
No, because Lordship, Rajneesh versus Neha's judgment says that the assets and liabilities is a mandatory, and that has never been taken from the parties. After taking, there may be two things. Either it may increase or it may decrease. I don't know what will happen. But that mandatory provision has to adhere with. So I disputed, earlier I disputed, it is there. Because I said that my mother is also sick. The area assessment that I have already disputed. Because only from my income directly it was taken into account. Saying that there are certain things, your lordship will kindly look into all these things. These are disturbing. The communication between the courts and the parties are disturbing. Because the words that has been used and the words that has been used in this order also are very disturbing. He has been saying certain things which I do not want to speak out in the open court. Your lordship will find that that is reflected in the order itself. He said that he was asked that no, your brother is also working. Why your brothers are not taking care of the parents? So how can I say in these things? Why my brothers are not taking care of the parents? I cannot say, because I have to take care of my parents being the elder son. So those things, those disturbing things are there. But if my assets and liabilities were allowed to be filed before the court, or the assets and liabilities of the other side, because the other side is also working. He is working in a mall. Those things are there. But never those assets and liabilities were taken into consideration. So if it is taken into consideration, two things may happen, Lordship. Either the arrear may come down or it may hike up. Either of the one. But my submission will be this, that definitely it will be in a lesser side. Because in that case, I can also prove my liabilities. Here my assets has already, only my salary has been taken into consideration. My liabilities has never been taken into consideration. I would be continue to pay that. Yes. The
Lordship,
13,500
Lordship.
continue to pay.
Lordship, I have also gone through the judgment, Lordship. So far as the affidavit on the point of the income of both the sides, as per Rajnish versus Neha, that has not been submitted by any of the party. That has not been considered by the learned trial court. From that angle, Lordship, this needs to be remanded. That apart, some more aspects are there. We are hopeful that it will be increased because of the fact that the case was filed in the year 2021, and he married another lady, and to get the relief from the punishment from the department, he had taken VRS in the year 2023, and in the year, from his evidence, in the year 2023, he was drawing 60,000 rupees. Thereafter, certainly it will come down, taking VRS, this pension. So from 21 to 23, till this taking VRS, so his income was much higher, on the higher front. Those aspects are also not being considered by the learned trial court because of the fact that the affidavit has not been taken from the both the sides. Even if, yes, I also do this in a private job, retailing, this doing something this as a lady. So yes, the affidavit, we will also file affidavit, and that affidavit has to be filed him also. That affidavit as per the annexure, as per the requirement of the Supreme Court. Yes. Yes, lovely. Yes, sir. Yes, sir. 3 lakh something. It's still pending. Yes.
13,000 I'm
Yes.
paying, Lordship.
But yes,
Fresh assessment.
area. Yes. Lordship, I would like to submit
No,
this,
if Rajnish versus Neha's judgment is to be taken into consideration, Lordship, then the entire amount of this 13,500 needs to be stacked off. Because, Lordship, I am saying that the assessment itself is wrong. Because my senior colleague has said that in order to escape from the punishment, I have gone for a voluntary retirement. These are not aspects to be looked into. It's a case of maintenance under 125. Whether these aspects are to be looked into.
no,
My punishment.
I'm not on that. I'm not on that.
My submission before Lordship, my
Salary. I am on salary.
my submission before
uh,
Lordship, because that assets and liabilities has not been taken into consideration, because the affidavit is of liabilities as well as assets. My liabilities could not be taken into consideration by the court. And if my liabilities could have been,
Remanding.
fresh assessment. That has to be stacked off. That has to be stacked off.
No.
The entire has to be stacked off, because they will do a fresh assessment. Fresh assessment, maybe less, maybe more. Only
Yes,
thing,
no.
Lordship, only thing that till no, I am not saying that. Till this reassessment is done, the 13,500 which I am paying, I will pay. But if it is more, then I am entitled for a refund. If it is, that means if it comes down, suppose 13,500 comes to 10,000, then two things can be done. Already the amount of money which I have already paid, that may be adjusted, Lordship, or that it to be refunded. Refunded will never be done because it's a social welfare legislation, I understand. Considering every aspects, then it will be adjusted.
Then certainly it will be adjusted.
It will be adjusted.
Because it will be on the basis of the order. What will be the amount, and as because you have already paid, that will be this
Adjusted.
part of the payment. That is
So,
but
Lordship,
so far as the Lordship's query is concerned, so what will be the this area as of now?
no, there is a stay by this honorable court, Lordship. There is a stay.
Stay is
So-
not
so that-
stay is not a coercive measure.
Yes,
Even that
yes,
means
the order is very
warrant was issued. That the only that even
No, no,
even
no,
after
no.
that, yes, even after that this order, he has paid amount 1,50,000 or
The quote was so heavy, every day I was under a threat that if I don't pay the amount, an non-bailable warrant will be issued against me. Lordship, will kindly see, after a final order has been passed, without there being any execution, the court was continuing in that manner. Is it legally permissible, Lordship? No execution was filed, nothing was filed. So moto, the court was continuing. I would not want to say all these things regarding any act of any trial court or whatever it is.
Lordship,
But
we
that
are
has prejudiced us. And that
Lordship,
is
we
why,
are-
taking into consideration that part, the court has hold that no coercive measures to be taken.
Lordship, we
But
are not on
Lordship, I am-
Lordship, we are not on merit, Lordship. What my humble submission is that, as because this they have also agreed to pay the this
Yes,
present
that
maintenance,
will pay.
and I will also agree to receive the present maintenance, and this court may direct that a time frame may be given to the trial court to take the affidavit of both sides and dispose of the matter as early as possible. And till then they have to pay regularly the present maintenance. That is my submission. Obliged.
Lordship, will it continue? That we are ready to pay.
Obliged.
That we are ready to pay, Lordship. Yeah,
Yes,
Lordship
Lordship.
may
Yes,
kindly
Lordship.
fix a date, Lordship.
Kindly fix a date, Lordship. Yes, sir.
Third week of June, Lordship. I think that is what is the order also
Specific
reflects.
date, Lordship.
I think there is a date for payment of the maintenance. That date can be fixed. TCR, I think it will be reflected in the TCR, Lordship. I think one date is already fixed, on which date I am paying the maintenance. That date may be fixed. Otherwise, there will be many confusion regarding two dates will be there. I think it is there in the TCR, if I am not wrong. Yes, Lordship. I am paying on that every month. That is my instruction, Lordship. I don't know what is in the TCR. I could not look into it. অলপ চাই দিওঁ। Third, that's what I'm saying. Third week. Or Lordship may fix a date, Lordship.
Lordship may fix a
Fix
date.
a date. Fifteenth, I think, will be a proper date. It may be 15th of the month, Lordship. 15th will be because he will receive his salary also by that time. Then it will be third week. It will be convenient in his part, Lordship. 15th of June, Lordship can fix it for appearance. 15th of June. Do we need to come back, Lordship, for the passing of the order? I'm deployed, Lordship. I'm deployed.
My lord, Lordship, I want to clarify one thing, my lord. Earlier, today the case is fixed, and in the meantime, interim order, if any, if it is CAB, my lord, that cannot be, but delivery of order, my lord, interim should be continued. This is the order, my lord. I have the order. Interim may be continued till the 10th. And in the meantime, my lord, the case is that date is there, my lord. In the meantime, my lord, that is there, my lord. Date. Otherwise, my lord, that is always fixed for necessary order, my lord. In the otherwise, my lord, that will protect.
For delivery of judgment, item number 20.
The appeal stands dismissed and disposed.
For delivery of order, item number 21.
The bail petition stands rejected.